It's time again for Legal Talk here on eRadio, and joining us from nice and wet Joburg is Nirvana. Oh no, sorry, you're in Pretoria. Nirvana Nothnagel, Associate Attorney at Hahn Hahn. But it's still wet in Pretoria, isn't it, Nirvana?
No, it is, and it's lovely. It's a beautiful reprieve from the heat.
Nice. I'm happy for you. Will you just send us some down here, please?
Well, pray for you guys so that you get some nice stormy weather.
That would be fantastic, really. But anyway, we had a poll on the LinkedIn last Friday, and we asked the question, are you aware of what the requirements are for a valid last will and testament, and the different types that can be formulated? So the majority said yes, that's 57%, and 43% said no. So the consensus is yes. So today, talking about wills here with Nirvana. Nirvana, what are the requirements of a valid will here in South Africa?
Okay, so firstly, in terms of Section 21A of the Wills Act 7 of 1953, this sets out pretty straightforward requirements for a valid last will and testament. Your requirements are that the testator must be older than 16 years of age. The testator must be mentally capable of understanding the consequences of his or her actions at the time that the will is drafted. The will must be in writing. So you can either choose to handwrite it or to type out the words, but it must be legible and in your own name. The testator must sign at the end of the will. The testator must request a person to sign his or her on his or her own behalf. In such an event, the signature must be made in the presence of the testator, at least 2 competent witnesses, and a commissioner of oaths. The commissioner of oaths must certify that the will has been signed in front of him and in front of the witnesses, and must sign each of the pages. Okay, the testator may sign their will by making a mark or thumbprint in the presence of at least 2 competent witnesses and a commissioner of oaths. The commissioner of oaths must certify that the will is signed before him and the 2 witnesses, and that every page is signed. The witnesses may not sign by making a mark or thumbprint. If the will is longer than 1 page, the testator or someone on his behalf must also sign every other page of the will anywhere on the page. The testator's signature on the last page must be made or acknowledged in the presence of 2 competent witnesses who are present at the same time. And then lastly, the witnesses must sign the last page of the will. The signatures can be made anywhere on the last page, but it's recommended that they are made below or as near as possible to the last line of the will.
Okay, I was just going to say now, if you have really bad handwriting, maybe you're a doctor, it's probably best to type it out, because can you imagine the people fighting afterwards, No, that's a 6. No, that's an 8, man. That's a 6. No, it's an 8.
We're going to have a handwriting expert come in.
Ew, imagine the drama, hey? Imagine the drama. That's probably best to type it out, not to have any confusion, especially if you're a doctor, because, you can't read anything written by a doctor unless you're a pharmacist. Okay, but when signing a will, what should individuals making the will take special care with?
So you need to ensure that your witnesses are independent. So in other words, your witnesses cannot be your nominated executor or beneficiary or their spouse. If your will is written in your own hand, obviously, except if you're a doctor, please just type it out. If this is not possible, then you make sure that your will is not written by your nominated executor, beneficiaries, or their spouses. Any blank spaces on the will larger than 10 centimeters should be struck through and initialed by the testator to avoid any provisions being added to the will by someone else at a later stage, if possible, and avoid drafting a will with large blank spaces. You should also make sure that you date your will, because in certain instances, a person may have drawn up more than 1 will. So in order to know what the most recent will is, it's best to sign and date your will.
Yeah, I agree. What can be contained in a will, Nirvana?
So our Constitution, Section 25, gives us what is known as the freedom of testation, and it grants the testator extensive power to draft a will which directs how his or her estate's assets must be distributed upon death. A will allows the testator to dispose of a whole or any part of their estate So, for example, you can include immovable property, jewelry, shares, unit trusts, or even your collector's items like your stamp collection or coin collection. Basically, as long as it's not illegal, impractical, or against public policy, you can leave anything to anyone in your will, provided your will is valid. But there are obviously limitations to this freedom of testation, which must be kept in mind. For example, a provision of a will cannot be exercised where it's unlawful, against good morals, or too vague or impossible to perform. Minor children of the deceased will have a common law claim to maintenance. And there's also the application of public policy and Section 13 of the Trust Property Control Act 57 of 1988 to negate the effect of unfairly discriminatory exclusions in testamentary charitable trusts.
And then what type of wills are there here in South Africa?
So we have, for example, a simple will. This would mean that the deceased has passed testate. This is where you leave a valid will upon your death, and your estate is divided and administered according to your wishes. A simple will is what is commonly referred to as just merely a will, and is what we have just discussed in broad terms. Then you have a testamentary trust will. This kind of will places assets into a trust for the benefit of beneficiaries and names a trustee to administer the trust. This type of will is often used if beneficiaries of the deceased estate are minors, or in the alternative cases where the beneficiaries are unable to manage or handle the assets they inherit on their own. Then you have a joint will. A joint will is signed by two or more people as a separate will for each testator. A living will. With a living will, this is not an act. It is not a will as what we've just discussed. This basically is a document that is used while you are still alive to provide guidance to your family and medical doctor regarding end-of-life medical care and treatment. Through a living will, you can request that certain medical treatment aimed at prolonging your life will be withheld in circumstances where there's no hope of your survival, such as if you are in an irreversible vegetative state with no hope of recovery. In addition, your living will can also be used to express your desire not to be resuscitated, identify the forms of medical intervention you would be comfortable with at the end of life, and for organ and tissue donation. So a living will is essentially a totally separate from your last will and testament, and serves a completely different purpose.
Okay. And what happens if I don't have a last will and a testament?
So if you fail to draft a valid will, and you will then have passed interstate. In this instance, your assets will be distributed in accordance with Section 1.1 of the Interstate Succession Act 81 of 1987, either wholly or in part. So example of this is that if you're survived by a spouse but not by a child, then the spouse shall inherit the entire interstate estate. If you're survived by a child but not a spouse, the child shall inherit the entire interstate estate. But we also need to remember that if a child is a minor, this is where, it becomes a little bit of an issue, because usually they would not be able to inherit. So you would have to create a testamentary trust. So then you would have to consider what the options are there in terms of that minor's inheritance. If you're survived by a spouse as well as a child, then the spouse will inherit the child's share of the interstate estate. And if you're not survived by a spouse or a child, but by both parents, the parents will inherit the interstate estate in equal shares. Or if one parent is alive, then that surviving parent will inherit one half of the interstate estate, and the children of the deceased parent, being the siblings of the deceased, will inherit the other half.
All right, and what are the key aspects to take away from the process of drafting of a last will and testament?
So the drafting of your will is a vital step in securing your legacy and safeguarding your loved one's future. So you need to clearly outline your beneficiaries, your assets, appoint an executor, and set out as clearly and precisely how you want your estate to be distributed. You should also seek legal guidance to ensure your will adheres to the relevant laws and accurately reflects your intentions, and that you fulfill the requirements of what a valid will is. Because if you don't, there may be instances where your will is not deemed to be valid.
Yeah, you don't want people fighting about your stuff after your death, we've seen that so many times. So lots of funny movies. There's actually one called The Estate, which is a hilarious movie about this kind of thing. But you don't want your loved ones to fight about your stuff after you're gone. So make sure you've got your stuff in order,
No, definitely. And this, by just drafting your will and putting everything in writing, you eliminate any animosity at the time of your passing and any infighting within the family.
Yeah, no, a lot of people say, I don't want to do it because then I'm going to jinx my life, or I don't want to talk about death or even think about it, but we have to, Life's unpredictable. You never know what's going to happen. You could live to 100. You never know. Or you could live until tomorrow. So... Oh, that's morbid, rather grim. But morbid. Must be your Gauteng weather coming through the phone here or something. Nirvana from Hahn Hahn Attorneys. Thank you so much. That was very interesting.
Thank you, Ian. It was a pleasure.
Are you or your business in trouble and struggling to find a solution? Call Hahn Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations, and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn Hahn Attorneys, Wednesday mornings at 10 on eRadio.